Ladies and gentlemen, thank you for standing by. Welcome to the Campus SaVE Act 2014 regulatory updates. During the presentation, all participants will be in a listen-only mode. If you would like to ask a question during the presentation, please use your chat feature located in the lower left-hand corner of your screen. Your questions will be addressed at the very end of the presentation. Participants who've joined through the phone lines, if you need operator assistance, you may press *0. As a reminder, this webinar is being recorded today, Thursday, April 10th, 2014. I would now like to turn the conference over to Joe Duck, Education and Government Practice Leader. Please go ahead, Mr. Duck.
I would like to thank everyone for joining us today for the Campus SaVE Act 2014 regulatory updates. This webinar is brought to you by Workplace Answers, and your presenter is S. Daniel Carter. My name is Joe Duck, Higher Education Practice Leader for Workplace Answers, and I will be the moderator for today's call. Whether you're a regular or if this is your first time joining us, we're very happy to have you with us today. Before we get going, I'd like to tell you just a little bit about us. Workplace Answers offers the most compelling and interactive online compliance training solutions in the industry. We bring cutting-edge courseware and the latest training applications together with a dedicated professional services team to transfer the way that you educate your campus. A few housekeeping items before we get started. All audio will come through your computer speakers, so please ensure that your volume is turned up. You may submit questions to the speaker at any time today by typing directly into the chat feature, which will be located to the left of your screen. Please note that all questions will be addressed at the end as time allows. Unfortunately, we will not be able to provide the actual PowerPoint slides, but all registrants and attendees will receive an email in the next couple of days with information on how to view the archived recording of this webinar today. You may receive a call from one of our industry consultants after the webinar to ensure that you receive the link to the recording and to also get your thoughts on the webinar. We'll be conducting a few polling questions during the presentation and would appreciate your input. Just click the radio buttons to select your answer when prompted. While your individual responses will be kept private during the presentation, we will display the overall results for everyone as they come in. As a reminder, today's session is being recorded. Today's presenter, S. Daniel Carter, has more than 20 years of experience working to improve college and university campus safety on a national level while also serving the victims of campus violence. Daniel has worked to develop and secure passage of regulations for more than 6 pieces of federal legislation that include the Campus Sexual Assault Victims Bill of Rights, the 1998 Jean Cleary Disclosure of Campus Security Policy, and the Campus Crime Statistics Act. Live from Washington, D.C., S. Daniel Carter joins us directly following his work on the negotiated rulemaking process for the Campus SaVE Act. Daniel, we're delighted to have you join us today. Without further ado, I'd like to turn the call over to you. Please go ahead, Daniel.
Thank you, Joe, and thank you to everybody who has joined us. Good morning or good afternoon, depending upon where you are in the country. The Campus SaVE Act has been a project that literally hundreds of college and university officials, victim advocates, victims and survivors, and subject matter experts have worked on for the last 5 years. And I greatly appreciate you taking the time out of your day to learn more about it. And what we're going to be covering today really is the updates that have occurred during the recent negotiated rulemaking process. But before we get into that, I want to cover a little bit of background for folks. The Campus SaVE Act is an amendment to the Jean Cleary Disclosure of Campus Security Policy and Campus Crime Statistics Act, which was first enacted in 1990 as the Campus Security Act, and then most recently amended in 2013 by the Violence Against Women Reauthorization Act, which implemented the Campus Sexual Violence Elimination Act. Other key legislation includes Title IX of the Education Amendments of 1972, and many of you are familiar with the April 4th, 2011 Dear Colleague letter, which the Office for Civil Rights issued to discuss guidelines for handling incidents of sexual violence under Title IX. And many of the elements found in the Dear Colleague letter have found their way now into statute as a part of Campus SaVE. And Campus SaVE was enacted last March as a part of the Violence Against Women Reauthorization Act, Public Law 113-4, which took effect March 7th, 2014. And in essence, all annual security reports produced under the Clery Act this year are subject to the requirements of the Campus SaVE Act with the deadline of October 1st. And the Department of Education has stated that they expect good faith compliance effort. Now, what does the Campus SaVE Act do? There will be more inclusive crime statistics, including some major changes to how sexual assault crimes are reported. It enhances the 22-year-old Campus Sexual Assault Victims Bill of Rights by building on the educational requirements of that law, and it enhances conduct proceeding guarantees for both the accuser and the accused. And this is something that there's been a lot of issues come up recently about due process and civil liberties. The conduct proceeding guarantees are very strongly geared to protecting both the rights of the accuser and the accused so that there is a fully equitable process. The Campus SaVE Act will also call for a best practices report. And one of the things that has happened in the last few months is that President Obama has created a White House task force on campus sexual assault that will, among other things, be producing a best practices report. So we will have that. The timeline is by the end of April that we will have that. And the Campus SaVE Act also adds anti-retaliation and whistleblower protection. Now, we're not going to have time to cover a lot of these today. We're going to be focusing mostly on the most recent changes that came out of the process where a group of constituencies came together to work with the Department of Education. It's known as negotiated rulemaking. And the Department of Education will be publishing proposed regulations, and this is what we're focusing on. But there was a prior webinar that I did with Workplace Answers that really covers the basics of the Campus SaVE Act, and there will be an opportunity for everyone to review that as well. And if you did not have a chance to see it the first time around, I would strongly encourage everyone to go back and take time to watch it after they've participated in today's presentation. And I know we have a large audience, and hopefully we have a large, diverse audience, because under the Campus SaVE Act, a lot of people on college and university campuses have responsibilities. For far too long, the Clery Act has been looked at as something for campus public safety, police and security departments only. In reality, student affairs, deans of students, resident advisors, human resource officers, athletic team coaches, athletic directors, student organization advisors, and any other official with significant responsibility for student and campus activities, as well as anyone that your institution designates as someone to receive reports of crime, has responsibilities under the Act. So this is really a team effort on your campus, and it's important that everyone work together. That's probably one of the most important things to take away from this, is that everyone needs to be working together. And now we have a poll question.
Thanks, Daniel. This is our first poll question for the day. How prepared is your campus for the new SaVE Act regulations? If you would please enter your answer now, and we will tally those up as those begin to come through. All right, I can see the responses telling up here. It looks like we've got a good majority of folks that do feel like they have a team ready, that they simply at this point lack understanding. And the second there we can see is that those that are well prepared, and it looks like we have a few folks that are still either ill-equipped or have no idea. So. Good. Well, we will continue here, Daniel, and until the next poll question.
Well, we certainly hope we can get everybody a good baseline of the direction they need to be headed in. And that's an important point. What we have are proposed regulations, that the Department of Education is expected to publish by June. There will be a 45-day public comment period where everyone in the audience and anyone in higher education who will be affected by these regulations can offer their input. And I would strongly encourage folks who are participating who have questions or concerns to take a look out for when that is published, and to, if they have comments or questions, please to submit those to the Department of Education. Final regulations will be published by November 1st and will take effect July 1st, 2015. So I can give you a direction today that the Department of Education is headed in. No final compliance procedures should be put in place until those regulations are published by November 1st, 2014. And until then, the Department of Education has, as I mentioned earlier, indicated that they expect institutions to make a good faith effort. So I'm giving you a preview, and the final guidelines will be available in time for the reports that come out in 2015 and your compliance efforts in 2015. So now you're really just getting a head start on where everyone is going. We have several key updates came out of the final 2 days of the negotiated rulemaking process. Major changes to some of the crime reporting procedures, clarification about the confidentiality protections specific to the Campus SaVE Act, specifics to victims' rights, many important procedural guidelines for disciplinary proceedings, and additional guidance on the educational programs and campaigns that institutions under the Campus SaVE Act will be providing to all new students and employees and on an ongoing basis. One of the most significant changes to come out of the last session of negotiated rulemaking was a far more inclusive definition of rape. As many people may have heard, the U.S. Department of Justice initiated changes to the Uniform Crime Reporting Program and expanded the definition of rape. The Clery Act will now include this more inclusive definition of rape as a part of the reporting requirements. It includes offenses which were previously classified as sodomy and sexual assault with an object. Institutions will also now separately report fondling, incest, and statutory rape. And in one of the biggest changes, the hierarchy rule, which many of you may be unfamiliar with, provides that in a multiple offense situation, institutions only report the most significant offense. That no longer applies. So if an incident of sexual assault occurs, and the only more serious offense than a sexual assault is a homicide, but if both do occur in the same incident, both would be reported. And also the department has indicated that they expect that if there are multiple sexual assaults that occur within the same incident, that both of those are multiple numbers would be reported for that. So that's a major, major change. The new definition of rape is the penetration, no matter how slight, of the vagina or anus with any body part or object, or oral penetration by a sex organ of another person without the consent of the victim. This includes same-sex rape, which was something that even under the more inclusive definition of NIBRS was not included under rape. It was included under sodomy. And to be clear, it's a consent question. It's not a question of was there use of force. It's purely whether or not there was consent. And that does include when there's inability to give consent, such as due to incapacitation. There are also 3 new crime categories which are going to be reported separately from the main body of Clery Act crime statistics, and also separate from the hierarchy rule. So if an incident of dating violence would also be reported as a sexual assault, it would still be reported as a sexual assault or aggravated assault or other Clery crime that would be applicable, because these will be reported in their own separate subset of crimes. The definition of dating violence, domestic violence, and stalking have been adopted from the Violence Against Women Act. And dating violence is defined as violence committed by a person who is or has been in a social relationship of a romantic or intimate nature with the victim. And not all jurisdictions have a specific definition of dating violence in particular. Most jurisdictions do have definitions of domestic violence and stalking. Consistent with long-term clery expectations, if there is a crime such as simple assault or intimidation in your jurisdiction and it is committed, meets the definition of being committed by someone in a social relationship, then it's reportable as dating violence, even if there's not a specific crime of dating violence in your jurisdiction. And in the draft regulations, the Department is proposing to base whether or not there is a relationship on the reporting party's statement taken into consideration with the professional judgment based on of the institution, typically law enforcement, police, or security, based on the length of the relationship, the type of the relationship, frequency of interaction, whether or not there was sexual or physical abuse in the relationship or threat of such abuse. And it is important to note that it is mutually exclusive of domestic violence. If there is an incident of dating violence or if there is an incident of domestic violence, they are mutually exclusive. They are going to be reported separately because the type of relationship determines where it's going to be reported, and those definitions are mutually exclusive. Domestic violence is more specifically defined as a felony or misdemeanor crime of violence committed by a current or former spouse or intimate partner of the victim, a person with whom the victim shares a child in common, a person who is cohabitating with or who has cohabitated with the victim as a spouse or intimate partner, or a person similarly situated to a spouse of the victim under the domestic or family violence laws of the jurisdiction in which the crime of violence occurred. So this would include such things as domestic partner relationships, and this is one of the few areas where the specific laws of your jurisdiction will determine whether or not an incident is reportable. And finally, it's any other person against an adult or youth victim who is protected from that person's act under the domestic or family violence laws of the jurisdiction. Again, this is also dependent upon the local jurisdiction laws. One common question I will go ahead and address up front is, does domestic violence include people who are living together merely as roommates? And the answer is, so long as there is not an intimate or romantic relationship, then the answer is no. This definition is clearly intended to apply purely to people who have that type of a very specific relationship. So if two roommates get into a fight, that might be reportable somewhere else under clery, but it's not going to be reportable as an incident of domestic violence.
Daniel, this is Joe. Sorry to interrupt.
Hi, Joe.
I just wanted to remind there was a few folks that were frantically looking to write down these definitions. It's extremely important information. So I did want to just remind everybody that there will be links to review all of this material, and we do have a question and answer session at the end. So rest assured, they don't have to scramble to write it down. I know we've got a lot of material to cover. So sorry to interrupt. Thank you, Daniel.
And certainly everyone can go back and watch the webinar. It will be available for people. And I'm also going to try to find a way to get these definitions posted somewhere for everybody so that people can refer to them. Stalking, and this is one of the things that's very important to understand about stalking, it is a very unique type of crime. Most crimes are a single incident that occur in a single location. Occasionally, there may be two jurisdictions where a period of, a kidnapping or even an assault where it can sprawl over into another jurisdiction, but typically occurs in one place. Stalking, on the other hand, is a course of conduct offense, which can occur across vast distances, and that's one or more particular acts. So there must be at least two acts to constitute a course of conduct. And stalking is a course of conduct directed at a specific person that would cause a reasonable person to fear for that person's safety or the safety of others or suffer substantial emotional distress. And the Department of Education has clarified certain things, including that it's 2 or more acts, including but not limited to acts in which the stalker directly, indirectly, or through third parties by any action, and that includes electronic communication that may be over hundreds if not thousands of miles, method, device, or means follows, monitors, observes, surveils, threatens, or communicates to or about a person or interferes with the person's property. So it's a wide range of activity that is covered. And particularly clarified by the Department of Education are the terms substantial emotional distress and reasonable person in the proposed regulations. Substantial emotional distress means significant mental suffering or anguish that may but does not necessarily require medical or other professional treatment or counseling. And a reasonable person means a reasonable person under similar circumstances and with similar identities to the victim. So, for example, what a professor may consider to cause substantial emotional distress may not be the same thing that a student victim would consider that, because they're situated very differently, as would someone from a different type of culture or community. Someone from a foreign country may consider a particular course of conduct to be threatening, whereas someone in the United States would not understand why a particular course of conduct is threatening. But the reasonable person in this circumstance means the type of, someone from the group that the person who's being victimized is from. So that has to be taken into account. And this is really going to require a culture shift in how many of these reports are received. So that's going to take, I think, some thought on institutions' parts about how they respond to reports of stalking. Now, counting stalking was one of the more challenging tasks that we had at negotiated rulemaking. And the department is proposing that the stalking incident be first reported in the calendar year in which it was first reported, which is consistent with current Clery procedure. It will be recorded in subsequent years if the course of conduct continues and, of course, is reported in subsequent years. And it is recorded only at the first location in which either the perpetrator engaged or the victim first became aware. So if you know that the perpetrator sent it from campus, it's recorded on campus. If you know that the perpetrator engaged in it from a non-campus property, that's where it's recorded. Similarly, if the victim first became aware of the course of conduct in their residence hall room, even if the conduct was, say, a Facebook post that was made from on the other side of the country, that is going to be recordable in the on-campus student residential facility category. And the department has preliminarily said that if the conduct is initiated on one campus and the victim becomes aware of it on another campus, and it is reported to both campuses, that it is reportable by both institutions. Institutions must have significant procedures in place now to protect victim information. And the reason for this is one of the most chilling effects on reporting of sensitive crimes is the victim concerns that their information, that their name will get out in their social circles or publicly. So under the Campus SaVE Act, institutions must keep victim information confidential and must specifically have a policy statement about how they will accomplish this task. And there is an exception if needed to provide accommodations. So for example, if a student wants to have their assailant transferred to another class section, obviously if there's action being taken, the other individual is going to be identified, notified, and you cannot guarantee complete confidentiality, nor could you if, for example, you were conducting a conduct proceeding. So there are exceptions for when the institution is required to act in compliance with the Campus SaVE Act, Title IX, and other legal requirements. And the statement in the annual security report must specifically address public record keeping. This is particularly important for public institutions. So if an institution is subject to a public records law and incident is reported to the campus police department, then the statement must address, to the extent possible consistent with state law, how information will be kept confidential. If state law requires that certain information be disclosed either in a public police report or in court documents, that will need to be noted, as well as how information will be kept confidential in Clery Act reporting, which is typically far easier because Clery guidelines, both for crime statistics and the crime log, have long required that victim information be confidential. And the Campus SaVE Act regulations now also specifically provide for keeping information confidential in timely warnings. Anything that might identify the victim should specifically be kept out of a timely warning report. The Department of Education has adopted the definition of personally identifying information found in the Violence Against Women Act. I've included the citation, which is 42 United States Code 1395A20. And it's defined as individually identifying information for or about an individual, including information likely to disclose the location of a victim of domestic violence, dating violence, sexual assault, stalking, regardless of whether the information is encoded, encrypted, hashed, or otherwise protected. And there is an extensive list of specific information such as first names, addresses, contact information, and this is one of those lists that's going to be important for people to go back and refer to. It is different from FERPA confidentiality provisions, and it is something that institutions are going to have to adopt specific policies and procedures to address. Under the Campus SaVE Act, there are also critically important new victims' rights, which include written notice of rights and options for all students and employees who report, that they have a right to accommodations, whether they report to law enforcement or not, for the changing of academic, living, transportation, and working situations if requested by the victim and if they are reasonably available. So, for example, if a victim requests to be transferred to another class section because they're in the same class with their assailant, and there isn't one, then it would not be reasonable to, an institution is not expected to take extraordinary measures. However, if there is another class section, one of the students is expected to be allowed to transfer. And again, it will really depend upon whether the victim wants the other person to know about it and whether or not they're taking action against them in a conduct proceeding. So that's the type of reasonableness standard that the department will apply. Disciplinary proceedings, and many of you who are familiar with Title IX guidelines will find some of these terms somewhat familiar. Disciplinary proceedings must be prompt, fair, and impartial. Promptness under the proposed regulations is to be determined by the time frames disclosed by the institution under their annual security report. The Department of Education's Clery Compliance Division has said that they will use a reasonableness standard in evaluating these guidelines. So for example, if an institution said cases would be resolved within a year, it is very likely that that would not be considered reasonable by the Department of Education. I would also remind institutions that these requirements are separate from those under Title IX, which are enforced by the Office for Civil Rights, which has said that most cases should be resolved within 60 days. And the Office for Civil Rights has obviously said that in more complicated cases it may take longer. And what the proposed regulations here would say is that a time frame may be extended for good cause with notice to both accused and accuser of the reason for any delay. And both accused and accuser are entitled to timely access to information to be used in the hearing. For example, one of the things we discussed was that giving an individual 24 hours to become well acquainted with hundreds of pages of the case file before a hearing would probably not be considered reasonable or timely in this context. It's also important to bear in mind that the prompt, fair, and impartial requirement applies at every step of the process, from initial investigation to the final post-appellate result. The proceedings are to be conducted by officials who receive annual training, and the accuser and accused are entitled to the same opportunities to have others present. This includes an advisor, And in this context also includes witnesses and other individuals who may be participating in the proceedings. And speaking of advisors, one of the other most significant changes to come out of the negotiated rulemaking process, and what many of the people at the table felt was probably the single most significant policy provision to come out of negotiated rulemaking, was that the Department of Education interpreted the statutory language to say that they could not regulatorily permit institutions to place a limit on the choice of advisor that the accused or accuser is entitled to bring with them. They can bring an attorney, a local rape crisis counselor, or a parent. An institution, however, may establish restrictions on participation of this advisor so long as it applies equally to both parties. This means the advisor may be limited to a role of providing advice directly to the accused or accuser only, and is not entitled to participate in the process itself, unless the institution elects to allow that. The results of the proceedings must be provided simultaneously in writing to both the accuser and accused, must include the sanctions, if any, and the rationale for the result. Accuser and accused must also be provided of a notice of options for appeal, if any. There is not an absolute right to appeal, but if there is a right to appeal for the accused, the accuser is entitled to a right to appeal as well under the same circumstances. And if an appeal option exists, obviously it has to be available to both. Institutions must also provide the accuser and the accused of any notification of changes to the outcome of the proceedings under the same simultaneous writing requirement. Institutions are also now going to be obligated to provide much more extensive educational programs and ongoing campaigns than under the previous Campus Sexual Assault Victims Bill of Rights, which was first enacted in 1992. Primary prevention and awareness programs must be provided to all incoming students and new employees. In the proposed regulations, the Department of Education has elected not to specify the type of program, the content, the length, the duration, or how quickly it must be provided. However, as one of my fellow negotiators accurately pointed out, someone is only an incoming student or new employee for a limited period of time. And I would observe that that is certainly probably at most the academic period in which they were first enrolled or employed. So at a minimum, by the end of that academic period, I believe institutions would be expected to provide them with this type of programming. Institutions must also provide ongoing prevention and awareness campaigns for students and employees. And the definition that the Department of Education has provided is programming, initiatives, and strategies that are sustained over time and focus on increasing understanding of topics relevant to and skills for addressing dating violence, domestic violence, sexual assault, and stalking, using a range of strategies with audiences throughout the institution. And this is less direct than the programming for all incoming students and employees. The Department has also provided specific definitions of the type of content that must be provided generally. Primary prevention programming, and a good way to think about primary prevention programming is instead of treating the symptoms of a disease, it's inoculating against it. It's intending to change the cultures that tolerate sexual violence in our campus communities. And it's programming initiatives and strategies informed by research or assessed for value. And this can include purely something outcomes measurements done based at your institution. So there don't have to be peer-reviewed articles that says this program specifically works. It's a question of does it work for your institution? Or outcomes that are intended to stop dating violence, domestic violence, sexual assault, and stalking before they occur through the promotion of positive and healthy behaviors that foster healthy, mutually respectful relationships and change social norms. Educational programs and campaigns are specifically defined to mean community-wide or audience-specific programming, so you can have something that blankets the campus community or is directed specifically at, say, residential life, Greek organizations, athletic teams, particularly our academic departments, everything that, and many of your institutions are already doing these things. So one of the questions is going to be is making sure you catalog all of the current activities that you're doing and maybe updating them to make sure they meet the new definitions so that what you're already doing can be built into the Campus SaVE Act requirements. Bystander intervention means safe and positive options for proactively intervening. And risk reduction means options designed to decrease perpetration and bystander inaction and to increase empowerment for victims in order to promote safety and help individuals and communities address considerations that facilitate violence.
Thank you, Daniel. Certainly a ton of information, and I think most definitely some key takeaways are that from the negotiated rulemaking process last week, that clearly everyone across the country must be looking at revised policies and procedures, and that really the integration between different departments and organizations within a campus are affected from this legislation. You've got, you mentioned Title IX, changes to Title IX and the policies regarding sexual violence and prevention. Typically that's going to go into your HR, your Title IX coordinators, the student affairs folks. The student training is now required for all incoming students. So definitely those that are in student affairs or involved with student training will have to also be training students. And then the last piece would be the actual clery reporting, and those that are involved in the campus security or in charge of the clery reporting will definitely need to have systems in place to be able to update that for their campus crime log, daily crime log, and then how that is reported on the annual security reports. So lots of different areas that this law intersects, as well as Title IX, clery, and VAWA. So I know it was a lot of information today for those out there, and once again, we will be conducting a live Q&A session here in just a few minutes. And this is simply just an overview here to let you know that Workplace Answers certainly has the training courses that are developed. We've got state-specific courses that would help you address those that face challenges in trying to simply get something up and running quickly, and then how you manage that over your organization can be challenging. So we are certainly here to help, and would welcome those that have questions. Okay, so without further ado, we are at our last polling question here. If you're interested in taking a live tour of our online training courses, including our Campus SaVE Act products, and you'd like to have someone contact you after this webinar, please click the radio button, Interested, Contact Me. You'll be contacted one of our industry specialists for a 30-minute consultation regarding our products and services. If you're not interested in being contacted right now, you can select one of the other options that best fits you, or don't do anything, and we will certainly proceed here in just a minute to the QA. So Daniel, I hope you're ready, my friend. We have some questions that will be coming in the queue here as they were popping in, and quite a few good ones. So I know for those that are out there, I would like to say thank you for submitting your questions. Very excellent questions that are coming through, and I think we have time to address those. So as we move forward here, Daniel, I'm going to start with a few questions as they come through, and here we go. First question, what are the safe and positive options for bystander intervention in the employment context? Is there any published research on this?
I think in the simplest of what I would recommend is that institutions consult with professionals in your communities who do work on these issues to work with you to craft something that will work in your community. And also look for the best practices report coming out from both the White House Task Force by the end of the month and additional resources that will be provided by the U.S. Department of Education.
All right, thanks, Daniel. We have a question here regarding community colleges. Does the Department of Education have any suggestions for community college, both for effective education of the student body that may enroll and those that attend class within 24 hours, as well as for students who might enroll in a semester and then not take courses for 5+ years? Would they still be considered an incoming student? So kind of back to your point earlier of what's considered an incoming student. So if you can speak on that, any suggestions there, Daniel?
That's an excellent question, and what the U.S. Department of Education has promised is that they will provide extensive discussions of how these requirements impact different types of institutions, as well as in the Notice of Proposed Regulations, there's something called a preamble, which is a discussion that elucidates information in the proposed regulations. And as many people are aware, there is also a handbook. The team that works on the handbook was actively participating in the negotiated rulemaking process and will be providing an updated version of the handbook with extensive guidance geared towards different types of institutions once the final regulations take effect. And remember, until that guidance from the Department of Education comes out, they have said that they are merely expecting institutions to undertake a good faith effort. So, if you make a determination on someone who hasn't been enrolled for 5 years as a new student or not, I think so long as you've made a determination and made a good faith determination, the Department of Education will respect that until there's guidance that says different.
Right, that makes sense, Daniel.
You may also want to consult with your financial aid office because they will, how they determine who is a new student and who isn't is something that I would look to. I think a lot of people often forget that because this is tied to financial aid, there are a lot of elements in these requirements that you can get the answers on query requirements from your financial aid office, such as when is someone a student, what's a separate campus, what's a branch campus. Your financial aid office is going to have those answers.
Right. Our next question, the regulations require that training be, quote, assessed for value, effectiveness, or the outcome. And the question is, how would you suggest an organization, conduct the assessment?
In general, you're going to want to conduct an outcomes measurement survey, such as you do a pre- and post-test on the population that receives the training, such as you create a questionnaire of 10 questions on their understanding of what rape is, what consent is, what domestic violence is. You administer it to a sample of the population prior to them receiving the training. You then administer the same survey to a sample of the population after they have completed the training. And you document, for example, that going in, 25% knew the answer to question A. Coming out, 75% knew the answer to the question. And if the number doesn't increase or it goes in the wrong direction, you would then need to reassess the type of training that you're providing because it's not being documented as being effective. But it was very clear in our discussions that we were not talking about like peer-reviewed journals, although that's certainly something you can refer to. We're talking about basic outcomes measurements on the effectiveness to say, are the people who are participating in these educational programs learning from them? That's a baseline outcomes measurement test. I think it would also be helpful to take a look at reports. For example, if prior to administering the training you're receiving X number of reports, after you provided the training you're receiving, and you notice a percentage from year to year in increase in reports because people know that these are offenses, and they now know who they can report them to, because one of the things the training is supposed to include is letting people know what their options are and who they can report to. So one of the outcomes that you might expect to see, and that would be a positive of the training, is we've had a 33% increase in reports, for example, from calendar year 2013 to calendar year 2014.
Okay, thank you, Daniel. This one is one I often get a lot, so I know we've talked about this in the past, but There's a question regarding students that are online students, or universities that are typically have most of their general population of their students is an online. Does the incoming students include online students for this training?
Yes, online-only students are included for purposes of training and for accommodations. For example, if they're in an online course with someone who is engaged in stalking in particular, because the stalking itself could occur even within that online domain, or an incident of dating or domestic violence, the education component applies, the rights apply, the conduct proceedings apply, everything applies. The only thing that would not, unless it was documented that the incident was either occurring, perpetrated, or being first become aware of in a clear geography. So for example, someone is participating in an online class, but they're also a student who attends classes on your campus, and they become aware of an incident of stalking on your campus. It's going to be reportable statistically. But anything that, if someone is an online-only student and they're not on your campus, then it won't be reportable for statistical purposes. But all of the other provisions, education, victims' rights, conduct proceedings, all of that applies. Excellent question.
Right. So it's safe to say then, Daniel, that the answer would be yes, because you certainly can have online stalking and harassment that occurs online without stepping foot on a campus or a classroom, correct?
Correct. That is correct.
All right. Thank you. To kind of dovetail off that, I think there's some confusion here as well. There were some questions coming in regarding simply providing the training or actually showing proof of completion and mandating this type of education awareness training. So the question is the organization, university, simply responsible for just making it available, or do they actually have to show and mandate that every person there has taken this training?
That's an excellent question, and it is something that the negotiated rulemaking panel, including the Department of Education participants, discussed extensively. And in essence, where I heard the Department of Education coming down, and again, we're going to have to wait on the final regulations to know for sure, but they came down somewhere in the middle, is that they're not going to, for example, do an audit to see that you have a list of every student and every student participated in an in-person training. They're not going to do that. At the same time, merely saying, we have this online training course, it's out there, that's probably going to fall short of their expectations. So the final answer is probably going to fall somewhere in the middle, where there is an effort to get people engaged in the process, to have, for example, to have them participate in sessions during orientation, and in floor programs on residence halls for the ongoing or for new student portion. But the Department of Education has not indicated that they're going to say audit to make sure every name on a list of new students and new employees, literally like signed in, online or signed in on person to participate in a program. Right. So then, the training again. The question is, does it have to be in person or online? And your take on that is that it is what? That institutions are being given wide latitude in terms of how they offer their training. They can offer online training, they can offer in-person training, or they can offer a combination of the two. If the question is, does online training alone satisfy the requirement? The answer is that yes, it could satisfy the requirement so long as it meets all of the definitions. Right, and by definitions, Daniel, I'm assuming you're talking about we've obviously got the newest definitions right out of Washington there regarding local jurisdiction on domestic violence, dating violence, stalking, and sexual assault. Correct? Correct, and for what elements must be included about primary prevention, awareness, risk reduction, etc. So it would have to include all of those elements, but if it includes all of those elements, yes, online training can satisfy the requirements, as could a combination or solely in-person training, although a combination is probably going to be a good answer for many institutions, particularly for ones that have online-only students. Having online-only students complete an online course would certainly seem to make a great deal of sense.
Right. And the next question we have is regarding, you mentioned primary prevention programs, or what's also known in the legislation as primary prevention awareness campaigns. Question regarding the ongoing portion, and that I think some folks are under the impression that we do this training once, we put a check in the box. Is that good enough? Can you speak a little bit about the ongoing awareness education and campaigns and what that might look like?
Well, and really this is informed by prevention professionals who have told me that a one-time only program only has a short-term impact, that it does not have a lasting impact, that in order to truly be effective, there must be, and I heard someone call this booster shots, and that in order to be effective, there must be booster shots along the way to remind people about this training. And there's many forms that it can take. It could take everything from floor programs in residence halls to poster campaigns to having speakers come to campus, to having PSAs on campus cable systems. Any number of things that institutions are already doing fall into this category. It's just a question of making sure they're coordinated and reinforce the messages provided to all new students and new employees.
Right. So then on that note, Daniel, there's a few questions that have come in, and would it be safe to say that for those that simply either hand out a brochure or just provide information on a piece of paper to the students and that they receive that really when it comes up against if there were any litigation against the university, would that be enough to simply hand out?
Well, I think at first it's important. It's important to remember that under the Clery Act there is no private litigation. So anything you're looking at is an enforcement action with the Department of Education, and they have long said, that for the last couple of years, that they're going to be looking at this from a reasonableness context. If you had a one-time, effort where you handed out pieces of paper to people at the Student Center, first of all, you wouldn't be hitting a lot of employees by doing that, and employees have to be covered as well. That alone probably would not be sufficient. At the same time, there's not going to be a requirement that every person receives a flyer in their inbox. So something that everyone across the campus will be likely to see, or everyone who is involved in online classes would be likely to see, such as something that they would receive through email. Posters, banners, things like that would strongly reinforce the ongoing messaging would be effective. But the Department of Education has thus far, expressed a reluctance to micromanage and say, we're going to expect that you offer, say, 4 programs throughout a semester that reach X percentage of students. They've not indicated that they're going to say something that specific. And I know that there's a hunger to be told, we need to reach 80% of our students, we need to use these methods. And there will be additional guidance in the preamble to the proposed regulations and the final regulations as well as the handbook. But this is one of those areas also where the department wants institutions to be free to innovate, free to continue to learn from their own activities, to learn from literature. So there's not something that specific about what institutions may do. So it could include everything from a flyer to programs where off-campus speakers are brought in to any number of things. The key is that it be ongoing. And so I think what we can take from that is okay, you do your programming for all new students and employees, and then you have one day where you hand out posters. I think I can say comfortably a one-time follow-up event is not going to constitute ongoing. It anticipates something longer term across the full academic term so that it continues to reinforce those messages. As to the exact frequency and channel that takes, the department has not specified that, but like a one-time thing that only reaches a small percentage of your population probably would not be considered a reasonable compliance or even good faith compliance effort.
Yeah,
and the key is always going to come back to this. Justify and document your decisions. Institutions that get in trouble with the department frequently have failed to have a justification with a rationale for their course of action and failed to have documented it. Institutions that typically take the time to have a rationale and to document it generally fare far better when the department comes asking questions. And it's a good way to self-assess. I mean, ask yourself, as an institution and the people who are putting this on, does this seem reasonable to us in the light of day? And if it does and you can justify it because we're reaching as many people as we can, we're doing this several times, I think that's a far better guide than saying, well, we have to do it 3 times and reach X percentage of the population alone.
All right, thank you, Daniel. We've got time for a few more questions, so I did want to try to get through some. We definitely appreciate your input. I know that there's still some gray areas of law here, and that many of these answers are not black and white. If we could just take a minute to there's some questions here regarding employee type, whether they are visitors, summer camps, those that come on to the campus for a conference. Or those type of folks that are vendors, and would that be considered a population that the university would be will require some type of awareness training for them?
The department has, I believe, indicated, and again we'll have to wait to see the final guidance, that contractors would be covered. Someone who's in if a food service contractor, for example, they're on campus every day, they're going to be included. Summer camp type situations where the institution rents out a facility to a third-party organization, those individuals are not going to be employees of or students of the institution. It is unlikely that they would be covered. So it really depends upon the nature of the relationship that the institution has with the individual or group. Okay.
Next question here is regarding the victim's rights. We've got a couple questions here on that. So the first one is that there's a lot of emphasis placed on victims from the perspective of those who report sexual assaults. What is being done to protect the victims who have no desire to report or press charges?
Well, I think one of the common themes you'll find throughout is that there's no obligation to press charges. A victim can come forward and receive their Clery Act accommodations and have no obligation to report or have an investigation started. So if they reach out to an institutional official for assistance in changing a class section, for example, that's as far as it needs to go. And they receive written notification of their rights and options, and the rights and options are supposed to be part of the educational campaign. So every new student and new employee is going to be educated about their rights and options, including the fact that they don't have to file charges to get accommodations or receive assistance such as mental health or health care.
Okay, so then the university would not, the question is, how do we not re-victimize the victim by forcing them to do an investigation just simply because they shared information as a mandatory reporter?
Well, the proposed Clery regulations would specify that for Clery purposes there is no obligation to conduct an investigation, and the requirement under Title IX is widely misunderstood. I don't know that I have time to do it justice in the minute remaining. But their guidance has said that an investigation can constitute sharing the name of the alleged accuser with the Title IX coordinator for the potential of identifying a pattern. There's no obligation that an institution begin going around asking questions, collecting evidence, etc. An institution admittedly cannot do nothing when they receive that type of a complaint because there is a potential danger to the entire campus. But there's not an obligation to start interviewing witnesses, etc., under Title IX, and there is not under Clery as well. So, and I think that's been widely misunderstood. And the Clery Act also talks about providing specific confidential options, such as to anyone who receives information in privilege, such as a priest, rape crisis counselor, etc. And if that, or mental health counselor, and if that's the case, there are options to receive that assistance without any institutional obligations whatsoever, beyond providing the assistance.
Thank you, Daniel. And we do have an extra couple minutes here, as our moderator says we have. But I wanted to get this one last question, if we could. Again, regarding victims' rights and outcomes. Question is, could you discuss a little bit more, when a victim is entitled to know specific outcome of a conduct hearing, their understanding was that if a victim can only know a specific sanction if the incident was violent.
Well, and first of all, let me say that my email address is up on the screen, so if anyone has not gotten their question answered, please reach out to me. And to answer the specific question, this Act specifically requires, and for sexual assault, dating violence, and domestic violence, obviously all of that constitutes a violent crime. And there is a FERPA exception specifically for crimes of violence. So if students are at issue, that's covered. Stalking does not involve violence necessarily, but what the department has said is that because this specifically requires the disclosure of that information, it supersedes any other requirements. So this requires, if someone has been the victim of stalking and there's a conduct proceeding, the Clery Act now requires the disclosure of that result to the accuser, to the victim. And it's an absolute unconditional right, and it's irrespective of any other limitation in law on that information. So they have a right to it, and they have an unconditional right to it. They can share the outcome with third parties if they wish to. That's a precedent under the Clery Act.
Great. Well, thank you, Daniel. I really appreciate that today. We thank you again for joining us, and that was a wonderful presentation, jam-packed with a lot of information. And as a reminder, for those that attended today, there will be a replay of this webinar. And please visit workplaceanswers.com for more information on our Campus SaVE Act solutions and any other campus compliance solutions for your campus. We appreciate everybody's attention today, and thank you for joining. Have a good afternoon.